Hi, it's Mike DelSignore, Massachusetts OUI lawyer. In today's video, I want to talk about what are the 3 ways you can avoid jail if you're charged with a third offense, OUI in Massachusetts. This also applies if you're charged with a 4th offense and any offense higher than a 4th offense. But typically in the district courts, the most common are OUI 3rd and OUI 4th. So first way to avoid jail is obviously if you go to trial and you're found not guilty, then there'll be no jail sentence. So number 1 strategy is to prepare a great defense, win the case. Typically, if it's a 3rd offense, probably going to require a jury trial. The reason is while many cases are done with judges for 1st and 2nd offenses, judges know that you're charged with a 3rd offense. So at some point, that knowledge of your record, the judge won't be able to put it out of their mind in terms of deciding the case. So many judges probably wouldn't want to hear a 3rd offense as a bench trial. I have done 3rd offenses as bench trials. If the evidence is not there, the judge should be able to make the call in terms of saying that there's not enough evidence to prove a case beyond a reasonable doubt. So whether an offense is either 3rd offense, 1st offense, 2nd offense, the standard of proof is the same. The case is tried the same. It's just the stakes are higher. Second way to avoid jail if you're charged with 3rd offense is we can seek a reduction. So what that means is we go to the prosecutor and ask them to reduce the charge to a 2nd offense. Recently, I've had these cases reduced in Dedham District Court. I had 2 cases reduced recently in Dedham District Court from a 3rd offense to a 2nd offense where the person avoided a potential jail sentence. So you prepare a letter, usually to the head prosecutor of the court, requesting a reduction. And if that reduction is allowed, then there'll be no jail sentence. It'll be treated as a 2nd offense. The downside, however, is that it does count as a prior OUI if you ever received another offense, and it will count as a 3rd offense for license purposes. So this is the key thing. While you avoid the jail sentence, you don't avoid the harsh license consequences of a 3rd offense, which is 5 years if you refuse the breathalyzer, plus another 8 years. So if you took a breath test, you have an 8-year suspension. You probably could see the Board of Appeals between years 2 and 4 to get some kind of hardship. But if it's a refusal case, you're out of luck for 5 years. There's no hardship on a refusal suspension. So the license consequence can be critical in whether somebody wants to seek a reduction. The final way, and this is more common and there's more issues available now, is to try to vacate one of the prior OUI charges. So if you have 2 convictions, if you have one from between 2012 to 2019, you took a breath test, you might be able to get that conviction vacated as there's problems with the breath test machine. I've recently gotten convictions vacated in many courts, including Nantucket. I had a case vacated, Falmouth. Another one was vacated in Brockton. And all these cases resulted in 2nd offenses being reduced to 1st offenses. So there is a potential for a motion to vacate to be allowed, and they'll knock out that conviction. We also had one in Palmer District Court. So there's an issue with the breath test. So any breath test case from 2011 to 2019 is ripe for a motion for new trial. Now, there are other issues that sometimes come up with these old cases. Sometimes there's issues with the docket. You weren't advised of your rights. There could be other issues. Also, another way to avoid jail is they do have to prove this 3rd offense at trial. So I had a case once where they were able to prove the underlying offense, but the subsequent offense, they didn't have proper documentation on it, and the judge found the person guilty only as it alleges a 2nd offense. So there is that possibility. But, certainly when you're dealing with a 3rd offense, you got a lot of sort of balls in the air. There's a lot of considerations, a lot of paths you could take on the case. Do you want to fight it? Do you want to try to avoid jail? So for people that want to avoid jail at all costs, those are the things we usually do. Look at the prior convictions, write a reduction letter, and during the case, I would encourage you to do any kind of treatment you can do, because that will help us convince the DA to get a reduction. So in other words, you want to do proactive treatment. Normally on a 3rd offense, a lot of times you are on conditions of release, such as alcohol-free with testing. So you want to be perfect on those conditions, but then anything additional you can do will certainly increase and enhance your chance for a reduction. My name is Michael DelSignore. I handle OUI cases all over Massachusetts. I've done a lot of 3rd offense cases. I've had these clients found not guilty after trial. On many of these cases, I've been able to obtain reductions, motions for new trial. So I'll explain sort of all the options available to you and show you how to best handle your case. Call, text anytime, 781-686-5924. I'm here to help. It's my passion to help people charged with OUI cases.